Question 1. Ram is 19 years old. His guardian was appointed by a court when he was 10 years old. Ram enters into a contract today. Is Ram competent to contract? A. Yes, because he is above 18 years of age. B. No, because the age of majority for him is 21 years. C. Yes, because court-appointed guardianship has no effect on majority age. D. No, because he needs guardian's written consent. The answer is B. And if you picked A, welcome to the most common trap in this entire topic. Here is the rule you must burn into memory right now. Under the Indian Majority Act, 1875, the general rule is that a person attains majority at 18 years. But there is a critical exception. When a guardian has been appointed by a court for a minor's person or property, the age of majority is extended to 21 years. Not 18, 21. So Ram, despite being 19, is still a minor in the eyes of law because his guardian was court-appointed. His contract today is void. The option suggesting guardianship has no effect on majority age is the exact opposite of the law. The Indian Majority Act specifically carves out this exception for court-appointed guardians, and the idea that written consent of a guardian validates the contract is a complete distraction. A minor's agreement is void ab initio regardless of any consent given by anyone. Now let's go one level deeper. This question tells you two things simultaneously: the rule about majority and the consequence of minority. What is that consequence? Let's find out. Question 2. Seema, age 16, borrows 50,000 Raf from a moneylender by falsely representing herself as 21 years old. The moneylender, believing her, advances the money. When the moneylender sues for recovery, the court will A. Decree in favor of the moneylender because Seema committed fraud. B. Dismiss the suit because the agreement with a minor is void ab initio. C. Allow partial recovery based on doctrine of estoppel. D. Compel Seema to pay because she misrepresented her age. The answer is B. This is the Mohori Bibee v. Dharmodas Ghose principle, and it is the most tested case in this entire chapter. The Privy Council in 1903 held that a minor's agreement is void ab initio, void from the very beginning, as if it never existed. Not voidable, not valid, void. Now here is the trap embedded in this question. The doctrine of estoppel says that if you make a false representation and another person acts on it, you cannot later deny that representation. Sounds like it should apply to Seema, right? Wrong. The doctrine of estoppel does not apply to minors. A minor is never estopped from pleading minority, even if they fraudulently misrepresented their age. The law protects minors absolutely in this regard. Fraud by a minor does not convert a void agreement into a valid one. The moneylender's suit will fail. The court cannot decree recovery of money lent to a minor because the entire transaction is non-existent in law. What about the option suggesting Seema must pay because she misrepresented? That sounds like common sense justice, but law is not always common sense. A void agreement produces no legal obligation on either side. Question 3. Consider the following statements about a minor's agreement. Statement 1. A minor's agreement is voidable at the option of the minor. Statement 2. A minor cannot ratify a contract after attaining majority. Statement 3. A minor can be a promisee or beneficiary under a contract. Statement 4. A minor's agreement becomes valid if both parties consent. Which of the above statements are correct? A. Statements 1 and 3 only. B. Statements 2 and 3 only. C. Statements 1, 2, and 3. D. All 4 statements. The answer is B. Statements 2 and 3 only. Let's go through each one. Statement 1 says a minor's agreement is voidable at the option of the minor. This is the single most popular wrong answer in this chapter. The correct position, settled in Mohori Bibee, is that a minor's agreement is void ab initio, not voidable, not void at the minor's option, but absolutely void from the beginning. Void means it never came into existence. Voidable means it exists but can be set aside. That distinction is everything. Statement 2 is correct. After a minor attains majority, they cannot ratify a contract made during minority. Ratification requires a pre-existing valid obligation. Since a minor's agreement is void from the start, there is nothing to ratify. You cannot breathe life into something that was never alive. This is a major trap. Students assume that once the minor grows up, They can simply confirm the contract and make it binding. That is not the law. Statement 3 is also correct. A minor can be a beneficiary or a promisee under a contract. The law protects minors from being bound by obligations, but it does not prevent them from receiving benefits. So if you promise to give a minor a gift or to pay them money, the minor can enforce that against you. The protection runs one way. Statement 4 is completely wrong. Mutual consent of both parties cannot validate a void agreement. Even if the minor says, "I agree, please consider this valid," it changes nothing. Void ab initio means even the most enthusiastic consent cannot resurrect the contract. Question 4. Assertion A. A minor who has received money under a void agreement can be asked to restore that money by the other party. Reason R. This is because a minor's agreement is void, and therefore no rights or obligations arise under it. A. Both A and R are true, and R is the correct explanation of A. B. Both A and R are true, but R is not the correct explanation of A. C. A is true, but R is false. D. A is false, but R is true. The answer is C. Here's the nuance. The assertion is actually true. A minor can be compelled to restore benefits received, but only if the original goods or property are still traceable and identifiable. This is the rule of restitution under equity, not contract law. Section 41 of the Specific Relief Act and general equitable principles allow courts to order restoration, but the reason given is false. And this is the trap. The reason says no rights or obligations arise. That would mean no restoration either. But courts have carved out an exception. While the contract produces no enforceable obligations, equity steps in to prevent unjust enrichment of the minor at the other party's expense. The minor cannot keep the benefit and hide behind by initio. The court will not order money compensation if the goods are no longer traceable. Restoration of the actual benefit, not damages. Question 5. Ravi, a minor, supplies coal to Priya, a person of unsound mind, which is unnecessary for Priya's household. Priya's husband later refuses to pay. Under the Indian Contract Act, the supplier can A. Sue Priya personally for the price of coal. B. Recover the price from Priya's property. C. Recover the price from Priya's husband personally. D. Not recover anything because both parties are incompetent. The answer is B. Now, this question is testing Section 68 of the Indian Contract Act, and it is testing it with a double twist. Section 68 says that if a person supplies necessaries to a minor or a person of unsound mind, the supplier is entitled to be reimbursed from the property of such minor or person of unsound mind, not from them personally, from their property. So Priya cannot be sued personally because she lacks contractual capacity. The husband has no personal liability here unless he specifically contracted. But the supplier is not left without remedy. They can recover from Priya's estate or property. This is not a contractual right. It is a quasi-contractual obligation imposed by law to prevent unjust enrichment. What are necessaries? The Act does not define them exhaustively, but the test is goods and services suited to the condition in life of the incompetent person and their actual requirements at the time of sale. Coal for household use satisfies this test. Luxury items would not. This is often tested through illustrations. A minor being supplied law books for their studies qualifies. Expensive jewelry does not. The option suggesting nothing can be recovered misses the entire point of Section 68, which exists precisely to protect suppliers who deal with incompetent persons in good faith. Question 6. Which of the following is not a correct statement regarding a minor and agency? A. A minor can act as an agent and bind the principal to third parties. B. A minor acting as agent is personally liable to the principal. C. A principal can be bound by a minor agent's acts. D. A minor cannot be held liable as principal in a contract of agency. The answer is B. The law has a beautiful asymmetry here. A minor can be appointed as an agent. When they act as agent, they bind the principal to third parties. The principal becomes liable for the minor's acts in the course of agency, but the minor agent has no personal liability to the principal. Why? Because the minor is merely a conduit. They act in the principal's name, not in their own, and a minor cannot be personally bound under any contract. So the relationship works like this. Principal is fully liable. Third parties can enforce against the principal, but the minor agent escapes personal liability entirely. This is different from the minor acting as principal. A minor cannot be a principal because the contract would be void. The statement in question, that a minor agent is personally liable to the principal, is precisely what examiners love to disguise as a correct statement. A minor cannot be personally liable in contract, whether they are acting as agent or in any other capacity. And connect this back to your mental map. Minor, no personal liability in contract, ever, in any role where contractual obligation falls on them personally. Question 7. A lunatic person enters into a contract during a lucid interval. Later, the other party discovers the person is generally of unsound mind and seeks to avoid the contract. The contract is A. Void because the person is generally of unsound mind. B. Voidable at the option of the other party. C. Valid because it was made during a lucid interval. D. Voidable at the option of the lunatic. The answer is C. This is the critical rule under Section 12, read with the illustrations to that section. Section 12 defines a sound mind for the purpose of contracting as a person who, at the time of making the contract, is capable of understanding it and of forming a rational judgment as to its effect upon their interests. The key phrase is, at the time of making the contract. The law does not ask whether a person is generally sound or unsound. It asks a snapshot question. What was the mental state at the precise moment of contracting? A lunatic, meaning someone who has recurring episodes of unsoundness, can validly contract during a lucid interval. During that interval, they meet the Section 12 test. The contract is valid and fully enforceable. The general history of unsoundness is irrelevant once you establish the moment of capacity. Now compare this with an idiot, someone born with permanent mental incapacity, with no lucid intervals. An idiot can never contract. There are no intervals of capacity. The contract would always be void. And the intoxicated person, temporarily incapable while intoxicated, capable once sober. Same logic as lunatic, but cause is different. If a person at the moment of signing is so intoxicated they cannot understand what they are signing, the contract is void. Once sober, they are competent. Question 8. Consider. Assertion A. The burden of proving unsoundness of mind lies on the person who alleges it. Reason R. Under Indian law, every person is presumed to be of sound mind until the contrary is proved. A. Both A and R are true, and R is the correct explanation of A. B. Both A and R are true, but R is not the correct explanation of A. C. A is true, but R is false. D. A is false, but R is true. The answer is A. Both the assertion and the reason are correct, and the reason directly explains the assertion. The law presumes sanity. This presumption means that if you want to escape a contractual obligation on the ground that you are of unsound mind when you contracted, the burden of proof lies on you to establish that fact. The other party does not have to prove your soundness. You have to prove your unsoundness. This mirrors the general evidentiary rule in civil law. He who asserts must prove. The presumption of sanity is strong, and courts will not lightly set aside contracts on this ground without clear evidence of incapacity at the relevant moment. This has been tested in assertions about who bears the burden. Do not get confused into thinking the sane party must prove sanity. They do not. The party claiming incapacity carries the entire burden. Question 9. Which of the following persons is disqualified from contracting by law, even if they are of majority age and sound mind? A. A person who has taken a loan and has not repaid it. B. A citizen of a foreign country with whom India is at war. C. A person who has filed for bankruptcy but not yet adjudicated. D. A government employee on duty. The answer is B. An alien enemy. A citizen of a country with which India is at war is disqualified from contracting with Indian citizens during the period of war. Any contract made with an alien enemy during wartime is void. Contracts that were subsisting before the war either stand suspended or are dissolved depending on the nature of the contract. The option about a person who has taken a loan, a debtor, has no contractual disqualification. Debt does not disable you from contracting. You remain fully competent. The person who has filed for bankruptcy but is not yet adjudicated as insolvent is also fully competent. Disqualification attaches to an adjudicated insolvent, someone declared insolvent by a court. Until that declaration, no disqualification. This is a timing trap. The status of insolvency begins at adjudication, not at filing. A government employee on duty has no general disqualification from contracting in their personal capacity. The third limb of Section 11, disqualified by law, captures alien enemies, adjudicated insolvents, convicts undergoing sentence, foreign sovereigns and ambassadors who cannot be sued without government permission, and corporations acting beyond their memorandum of association. Section 11. Ramesh, a minor, purchases a motorcycle on credit and, after attaining majority, promises to pay the outstanding amount. Is this promise enforceable? A. Yes, because Ramesh has now attained majority and can ratify past contracts. B. Yes, because the promise after majority creates a fresh, valid contract with new consideration. C. No, because a minor's agreement is void and cannot be ratified after majority. D. No, because a promise to pay a time-barred debt is unenforceable. The answer is C. This question is a masterclass in traps. Let us go through each carefully. The concept of ratification requires a pre-existing valid but unenforceable obligation that a party now confirms. Think of it like breathing life into something that was merely sleeping. But a minor's agreement was never asleep, it was dead from birth. Void ab initio means no obligation was ever created. There is nothing to ratify. The promise after majority is therefore unenforceable as a ratification. But wait, option B says there is a fresh contract with new consideration. This sounds plausible. Can the fresh promise after majority be treated as a brand new contract? The answer is still no, because a fresh contract needs fresh consideration. The old debt from the void agreement cannot serve as consideration for the new promise. It was never a valid debt in the first place. Consideration must be something the law recognizes as valuable, and a void obligation has zero legal value. Option D about time-barred debt is a distraction. That concept applies to Section 25(3) of the Contract Act, which deals with limitation, an entirely different domain. The rule is clean. A minor's void agreement produces no obligation, leaves no trace, and can be neither ratified nor confirmed in any form after majority. Question 12. Which sequence correctly represents the transformation from proposal to contract under the Indian Contract Act? A. Contract, agreement, proposal, promise. B. Proposal, promos, agreement, contract. C. Agreement, proposal, contract, promise. D. Promise, proposal, agreement, contract. The answer is B. This is the foundational sequence, and it has been tested as both a sequence question and as an assertion-reason. Section 2A defines a proposal. When one person signifies to another their willingness to do or abstain from doing something with a view to obtaining the other's assent. When that proposal is accepted, under Section 2B, it becomes a promise. When promises form consideration for each other, under Section 2E, you get an agreement. When that agreement is enforceable by law, under Section 10, it becomes a contract. Proposal, promotion, agreement, and contract. 4 steps, 1 direction, no reversals. And now the competency link. Section 10 says all agreements are contracts if made by free consent of parties competent to contract, for a lawful consideration and a lawful object, and not expressly declared void. Section 11 then defines who is competent: persons of majority, of sound mind, not disqualified by law. Competency is a prerequisite at the agreement stage itself. If a party is incompetent when the agreement is formed, you never even reach the contract stage. The chain breaks at the agreement link itself. Question 13. Arjun, a minor, commits a tort by negligently damaging Vijay's car while driving a car he borrowed under a contract. Vijay sues Arjun in tort. The court will A. Hold Arjun liable in tort because minors can commit torts. B. Dismiss the suit because minors are immune from all civil liability. C. Dismiss the suit because the tort arose from a contract and a minor cannot be held liable. D. Hold Arjun liable only if he has attained 16 years of age. The answer is A. The general rule is that a minor can be liable in tort. minority is not a defense against tortious liability. However, and this is the critical exception that examiners love, a minor cannot be held liable in tort if the tort is directly connected to and inseparable from a contractual obligation. Why? Because allowing the tort claim would effectively enforce the void contract through the back door. Law will not permit that. So the test is the tort independent of the contract, or is it essentially the same as enforcing the contractual obligation? In Arjun's case, the negligent driving is an independent tortious act. It does not require enforcement of any term of the borrowing contract. Therefore, the tort claim stands. Compare this with a scenario where a minor hires a horse for riding only and rides it to exhaustion. If the owner sues for breach of contract, fails, minor's agreement is void. If the owner sues in tort for damage to the horse, this is so closely tied to the contract of hire that courts have held the minor cannot be made liable through the tort route to achieve what the contract route cannot achieve. The option about age 16 is a complete fabrication. No such rule exists in Indian contract or tort law. Question 14. Assertion A. A person who is usually of unsound mind, but occasionally of sound mind, can make a valid contract during a period when they are of sound mind. Reason R. Section 12 of the Indian Contract Act provides that a person is said to be of sound mind for the purpose of making a contract if, at the time when they make it, they are capable of understanding it and forming a rational judgment as to its effect upon their interests. A. Both A and R are true, and R is the correct explanation of A. B. Both A and R are true, but R is not the correct explanation of A. C. A is true, but R is false. D. A is false, but R is true. The answer is A. Both statements are true, and the reason directly explains the assertion. The illustration to Section 12 makes this explicit. A person who is usually of unsound mind, but occasionally of sound mind, a lunatic with lucid intervals, may contract during a lucid period, and that contract is valid. The reason is the Section 12 definition itself. Capacity is assessed at the moment of contracting, not based on general mental history. The illustration on the other side, a person who is usually of sound mind, but occasionally of unsound mind, like someone who has episodes of delirium, may not contract during those episodes of unsoundness. Again, the snapshot test applies. Both illustrations appear directly in the Act and have been tested by examiners word for word. The phrase, "at the time when they make it," is the operative phrase in Section 12. Memorize it exactly. Question 15. Which of the following statements about Section 11 of the Indian Contract Act, 1872, is incorrect? A. A person disqualified by law from contracting cannot make a valid contract, even if of sound mind. B. A minor's agreement is void, but a minor can accept benefits under a contract made by a competent party. C. A person of unsound mind who contracts during a lucid interval creates a void agreement. D. An adjudicated insolvent is disqualified from contracting in certain respects. The answer is C. The negative question format, which is incorrect, demands extra focus. Students often race to find the correct statement and accidentally mark that. Slow down when you see not or incorrect. The incorrect statement here is option C, which says a contract during a lucid interval is void. As we established through Section 12, it is exactly the opposite. A contract during a lucid interval is valid. This is not void at all. So the statement is factually wrong, making it the correct answer to a which is incorrect question. Statement A is correct. Disqualification by law overrides mental soundness and age. An alien enemy, in wartime for instance, cannot contract even if perfectly sane and adult. Statement B is correct. This is the beneficiary rule. A minor can receive benefits under a contract they did not make. The protection flows one way, against binding the minor, not against enriching the minor. Statement D is correct. An adjudicated insolvent loses control of their property to the official receiver assignee, and their contracting capacity is restricted accordingly. Question 16. Match the following. Column A, 1. Mohori Bibee v. Dharmodas Ghose. 2. Section 68. 3. Section 12. 4. Alien enemy. Column B. P. Supply of necessaries to incompetent person. Q. Disqualified from contracting during war. R. Minor's agreement is void ab initio. S. Test of soundness of mind. A. The answer is A. Clean, complete. Mohori Bibee established void ab initio for minors' agreements. Section 68 is the quasi-contractual provision for necessaries supplied to minors and persons of unsound mind. Section 12 defines the sound mind test at the time of contracting. Alien enemy is the classic example of disqualification by law during wartime. This match the following format appears frequently and tests whether you have connected the statutory provision to the rule and to the case. Each element here represents a pillar of this topic. Void ab initio from a 1903 Privy Council decision. Quasi-contract from Section 68. Mental capacity snapshot from Section 12. Question 17. Kavitha, who is 17 years old, agrees to sell her house to Mohan for 5 lakhs. Mohan pays the full amount and Kavitha hands over possession. After attaining majority, Kavitha refuses to execute the sale deed and asks for the house back. Mohan claims she must either execute the deed or return the money. Which of the following is the correct legal position? A. Kavitha must execute the deed because Mohan paid in good faith. B. Kavitha must return the money because she cannot retain unjust enrichment. C. Kavitha is entitled to get the house back but need not return money. D. The agreement is binding because it was fully performed by both parties. The answer is B. This scenario brings together 3 interconnected rules. First, the agreement is void ab initio because Kavitha was a minor when she made it, so Mohan cannot demand specific performance. There was no valid contract. The deed cannot be enforced. Option A fails entirely. Option D is a trap that sounds sensible. Performance is complete, so why should the contract not be valid? Because void ab initio means the contract had no existence to be performed under. Performance of a void agreement does not validate it retroactively. Option C, Kavitha keeps the money without returning it, is what the courts will not allow. Here is where equity steps in. While the contract is void and creates no obligation, equity prevents unjust enrichment of the minor. The money is traceable. Kavitha received a specific sum. Restitution under equitable principles requires her to return it. She gets the house back, Mohan gets the money back. Neither party can use minority as a tool for enrichment. This is the Mohori Bibee principle combined with restitutionary equity. The law refuses to enforce the contract, but also refuses to let the minor exploit void ab initio status to keep another's property. Question 18. Under Section 11 of the Indian Contract Act, a person is competent to contract if Statement 1. He is not a minor under the Indian Majority Act. Statement 2. He is of sound mind at the time of making the contract. Statement 3. He is not disqualified from contracting by any law to which he is subject. Statement 4. He has the financial capacity to perform the contract. A. Statements 1, 2, and 3 only. B. Statements 1 and 2 only. C. Statements 2 and 3 only. D. All 4 statements. The answer is A. The 4th statement is the classic fabrication that examiners insert. Section 11 lists exactly 3 conditions: majority, sound mind, not disqualified by law. Financial capacity is nowhere in Section 11, nowhere in Section 10, nowhere in the Contract Act as a condition for competency. A pauper with no money can enter a perfectly valid contract. Competency is a legal status, not an economic assessment. Statement 1 references the Indian Majority Act correctly. Minority is determined by that statute, not by the Contract Act itself. Statement 2 incorporates the Section 12 definition. Statement 3 catches the 3rd limb: alien enemies, insolvents, convicts, corporations beyond their objects. 3 conditions, 3 only: majority, soundness, no legal disqualification. If anyone is absent, the party is not competent under Section 11, and the agreement under Section 10 loses one of its essential ingredients for becoming a contract.